Good morning, everyone. I see everyone is starting to trickle in. We just opened up our workshop on university partnering through the SBIR program. While everyone's trickling in, I'm going to give kind of a little pop quiz poll question that you guys can just put in the chat. Before we begin, we're curious to know if any of our attendees have received an SBIR award in the past, and if so, from what agency? Or if you have not received an SBIR award in the past, let us know and let us know if you're interested in a particular agency. So once again, for everyone trickling through, just if you could just put in the chat whether you've received an SBIR award in the past or not. If you have, to what agency, and if you have not, then to what agency would you be interested in applying to? And this is just for some just additional context for our presenters as we go, just with that context. I see one individual is hoping to receive funding through the USDA or NSF. Another is also interested in USDA and NSF, so some popular ones already. I'll give everyone just a few more minutes to come in if they're coming in late, and then we'll get started. Okay. So one more time before I get started, for anyone who's joining us, I see it's also been put in the chat, but have you received an SBIR in the past? And if so, to what agency? And if not, so what agency would you be interested in applying to? And I also see that you'll also ask, what agencies are you most interested in learning about? So with that, I'll kind of kick us off. So thank you everyone for joining us. Once again, this is our workshop on university partnership for SBIR grants. I have just a quick little plug I'd like to give of our website. This is a link to our SBIR STTR resource page on the ACA's website. You can use this link to check out the upcoming events, upcoming programming, the Arizona FAST grant, which is going to be opening up next month. That is a grant that you can apply to receive a $3,000 grant that can go towards costs associated with applying for an SBIR award, core facilities costs, incubator startups, anything that kind of goes into the pre-phase of applying and receiving an SBIR award grant. And once again, that opens up next month, and that's also something you can find through that link that I have just posted. It's once again, it is a link to our the ACA SBIR STTR Resource Center page. So I hope you guys check that out. I'm going to turn it now over to our presenters today. We have Sandy DeCossola and James Vickers. Sandy is an owner of Summit Contract Management LLC, located in Tucson, Arizona. The company is dedicated to helping inventors, entrepreneurs, and small businesses work with federal government agencies. Summit provides step-by-step guidance in government procurement, from the management of new intellectual property to contract closeout. James R. Vickers is currently an executive consultant for Summit. He has over 40 years experience in acquisitions and contracting, including major acquisitions, contract claims, international contracting processes, and value engineering. He is retired from Raytheon Missile Systems, where he served as Director of Contracts for Advanced Security and Directed Energy System product lines for Raytheon in Tucson, Arizona. So without further ado, I'd like to hand it over to Sandy and Jim. Thank you, guys. Take it away.
Okay, thank you, Kyle, and good morning, everyone. I'm going to start with a quick slide. Oops, I think I'm going to start with a quick slide. What I've labeled it Procurement Lifecycle. However, it turns out it's very useful to know about the cycle of an SBIR or STTR grant or contract. So you're coming here with your highly innovative invention or sometimes service, but more likely an innovation. And you, the first step would be to look into the 11 agencies that participate in the programs and find a solicitation to bid. You'll prepare your proposal. And when we talk about the proposal today and life cycle, we're going to show you how hiring third parties weaves intricately through this whole life cycle. You'll find yourself in a pre-award. Lately, NIH, if you're an NSF, are asking tons of questions in a pre-award about your accounting and about subawards and consortium agreements, etc. We'll walk you through the award, what kind of terms and conditions you want to have in place with these third parties, and how you keep an eye on these third parties when they're performing, and then what they'll owe you at the end during contract closeout. So with that said, I do want to start with a few definitions I'm going to walk you through, because even though we labeled this partnering with universities, depending on the agency, perhaps if you're interested in the Department of Energy, you would be more likely to partner with a national lab, let's say NREL up in Golden, Colorado, or Sandia, or Los Alamos. And also, there's a possibility that you may need to hire a consultant. You may need a subaward arrangement, a subcontract arrangement, which is pretty much the same thing, but looked a little differently depending on, I picked the two largest agencies, the National Institutes of Health and Department of Defense. And then on to that, NIH lately is using the word consortium agreements more in their documents, and just making sure everyone understands about that. So let's start with the consultant. And I'll give you an example of this. Often when you're, let's say you picked, I saw up there NSF, USDA. Let's say you picked the National Science Foundation, and you want to go into a topic on the Internet of Things, or you've picked a topic, but you're finding that you don't have all of the capability to perform your project with the people that are part of your company. So sometimes you'll want to engage with a consultant, and that would typically be an individual that is going to perform an extension of your technical scope of work. Even though they're usually individuals, they could be firms that also provide advice or services. So if you're working under the granting agencies like NSF, NIH, they're going to call the relationship, contractual relationship, a subaward when you're going to hire out, let's say, a university, another large company that might be doing a significant part of your scope of work. In the DoD world, that would be called a subcontract. And I pulled, and I'm just giving you for light reading, FAR definition of a subcontract. But knowing that these are all the things that you need to start looking at when you're thinking about your topic and the agency that you want to apply to. And as I said, NIH is using the term consortium, but understand that definition right from the NIH grants policy, it is the relationship between you, the recipient of the grant, and the organizations that you're going to collaborate with is considered a subaward. So you won't hear Jim and I talking about consortium agreements today. We're just going to call them subawards or subcontracts. So you figured out that, okay, you want to go forward with NSF. And what I highly recommend is first trying to at least scratch out your objectives for the technical area of your proposal. So really look at that closely to try and determine, who do you need to help perform this project in order to write a winning proposal, because it's really up at this point that you're going to need feedback. You're going to need to figure out how many employees you can fit in, a fairly small budget on a phase one. If there's technical consultants you might need. There also could be, as I said, the need for university partnership, national lab experience, or again, there may be another company that fills a gap that that opened up to you when you started writing down your objectives for this project. So with that being said, what I highly recommend, and this again is upfront during the proposal phase, is issuing a formal request to those partners that you would include. So this takes a lot of upfront work. And so especially if you're new to writing an SBIR or STTR proposal, I highly recommend that you at least give yourself 2 months at a minimum. I can't tell you how many people I meet who are, 3 weeks out or even a month, and it's simply not enough time when you have a lot of third parties that you're going to be working with, because you have to give them time. So anyway, I would say, 2 months at least out from when the proposal is due, you're going to issue a formal request, and this can be in a form of an email, but you're going to need to draft out the statement of work, the schedule, the budget that you're going to give. In this case, let's pick on ASU. Let's say you're going after an STTR. And as Jill was mentioning earlier before we got started today, the STTR program is highly underutilized. And what that means to you is that there's a higher probability of success because there's going to be less people that you're going to compete with. And so anyway, let's say you've made that decision to go after an STTR and you're going to use ASU as a subaward in the case of a grant or subcontractor for contracts. But anyway, you need to give them that couple months time because they're going to have a pretty significant signature cycle, approval cycle within the university in order to get you the documents you need. So you need to be figuring out the statement of work and schedule and the budget, and there is going to be some back and forth. So you want to allow for time for that. You might also want to tell them what kind, and Jim's going to talk about the different types of sub-award or contract types, and give them a heads up on the type of terms and conditions that you're going to put in your agreement. And I can't stress enough, you need to allow enough time for them to do that because there are going to be questions and edits going back and forth. Something also worth noting when you're
Sandy,
working, yes.
We have a quick question in the Q&A that I just wanted to make sure we got before we moved on.
Okay.
Actually 2 now, so I'll give them both to you. Can a consultant be vertically integrated into the company applying for the award, e.g. a parent company consultancy has a subsidiary applying for an award? Can the parent company be a valid consultant?
I believe it can, but you do have to be careful because there are some times I've heard it posed as, can they be an employee? And my understanding is yes, but it depends on the agency. Jim, do you want to comment on that?
I think that's about correct, yes. And of course, it still comes into your percentages too,
Right, right.
whether parents are large business or small business.
Yeah, very good point. If they are, well, if they are a large business, that's going to get a little sticky. Yeah, just meeting the requirement. I wasn't going to go into that, but technically, as the way the SBIR and STTR programs define a small business is on employee size, so it would need to be less than 500 people. And Kyle, what was the other question?
Should you stack your subawardees in the event that one or some of them may not be able to participate?
When you say stack, unfortunately, when you're submitting your proposal, I don't care which agency it is, they've all become very detailed in the sense that they're going to want a specific name and a specific budget from that entity. So unfortunately, you can't really stack them. You have to pick one, but absolutely, yes, you should have alternates if at time of award, the party ends up changing their minds. So yes, you'd want to have some backups, but unfortunately, you can't. In the proposal, you have to pick exactly the employees you're going to use, the consultants, and the sub-award or subcontractors, because they're asking very detailed. They want to know levels of education, hours, names, the UEI numbers now. They want a lot of specifics. So anyway, I'll continue. So for those of you who aren't familiar, there are requirements for SBIR and the STTR programs as to how much work in terms of dollar amount that you can actually hire out to third parties. So normally in a phase one, a minimum of the work in terms of direct, indirect, and fee costs must be 67% performed within, or 2/3 within the company. So that means all consultants and contractual relations or that you intend to use for third parties. And so, for example, if you were to receive a $150,000 phase one award, you are limited to hiring out only 50,000. On a phase two, that increases and the minimum becomes 50% that you have to perform. And then you are allowed to contract out 50%. And again, that's in terms of, it's measured by direct F&A, and I forgot to put fee on this chart. So STTR is a little bit different. And in phase one and phase two, it's mandatory that the company, the awardee, must perform at least 40% of the work, and that the minimum that you can parse out to the quote unquote STTR partner, so that's usually a university or the national lab or an approved research institution. It has to be a federal research institution. You're allowed to contract out 30%. So speaking of these amounts, so especially in the sub-awards, in the granting agencies, so USDA, NSF, NIH, Department of Energy, you're going to need to complete the same kind of detailed budget for that sub-award as you would for yourself. So that's the other reason to allot enough time. It's going to be a detailed form, usually an SF 424 form, that they're going to have to fill out. So, I just want to make sure everybody understands how much detail you actually need from these partners. And that's why it really needs to be ironed out really early on before the due date of the proposal. So, okay, so enough talk about, you've written the proposal, you're ready to submit the proposal. You're in that pre-award, you've been notified that you are going to indeed receive the award. What we've been seeing a lot, especially with NSF and NIH, is a lot of questions will start coming in from the program people from those agencies. And something that I don't find that our clients always understand is that you as the prime awardee are completely responsible for these third parties. So when you issue work, and Jim is going to go into, what's going to be involved in these agreements with these third parties, we want to make sure you're very clear that it's all on you as the prime awardee to manage these third parties. So I can't tell you how many times we've been working with contractors and all of a sudden, that's why I love that question about, should you stack, these third parties? Absolutely, because something can and will go wrong. I mean, not always, but a small percentage of the time. And then you're left, can you really perform this project if they were going to fill a gap that technically you didn't have within your company? So I just want to really stress that relationship, because we've been worked on a project where the Air Force was the agency, and my client kept asking, can't we get the Air Force to make this subcontractor do what they're supposed to do? And the answer is no, it's up to you to do that. So that's why these terms that Jim is going to talk about, a biggie to me is the use of the stop work term. And he'll get into that, why sometimes you may need to just stop and regroup because you only get a limited budget, and these third parties can eat up that budget and give you nothing in return if you don't carefully manage them. So anyway, some of the subcontractor requirements, again, you're going to want to negotiate a clear statement of work, price, terms and conditions. Sometimes this is more in a phase 2 realm, but you're going to want to have a reasonable understanding that these third parties get that they need to behave and act properly as government contractors. They may not be prime, but they're still held to the requirements. So again, these negotiations will include subcontract statement of work, the type that you're going to issue. Universities are usually going to want a cost reimbursable, and Jim will go into why sometimes that really makes it difficult for you as the prime. You're really going to want to iron out these intellectual property terms, and on an STTR, it's mandatory that you have an allocation of rights agreement. And we talked about that for those of you who attended our prior workshop. You're going to want to be clear about payment. Do you want to pay only after you get paid, and cost and profit and fee? So with that being said, I'm going to hand it over to Jim, and he's going to talk about the most common types of subcontract agreements that you're going to issue. And the first being firm fixed price. So here you go, Jim.
Thank you. Fixed price is really the most common. All the risk is on the contractor. Now, under these type of agreements, they're more like a grant, so you don't really have a super big risk if you don't do well, except you'll never do any work with them again. But the risk is on you. It has the maximum risk type, of course, the maximum reward. If you underrun this, you get to keep the money. Now, I don't know if anybody that ever really underran these, but if you did, you would get to keep the money, particularly for hardware contract. The administrative burden for the government and for you is very small. But to do this, it's really important that you have a firmly defined statement of work for the type of effort you're doing. The government does not recommend this for R&D efforts, but in this case, it's rather limited R&D effort that you can use it with. Is there a question here or something?
Oh, now I just switched to cost reimbursement type.
Okay. Under a cost reimbursement, cost plus fixed fee contract, the contractor, you the prime, receives a payment for all your allowable costs up to the extent that's limited by the contract. The statement of works are for low risk. They're more general. You can't really come back and complain too much if the things are out of scope, unless they really are out of scope. But fees are usually lower than the fixed price contract or R&D types contracts. And one of the problems with this is you do have to have an approved accounting system. And with universities and others, they will have an approved accounting system, but perhaps the people that are running the project, in the university are not that great at following budgets and things like that. So this can be problematic. They may have spent all their money before they get anything. Next slide, Sandy. Time and materials. This is a simple way to do things. You have direct labor hours that you pay for. You set a certain amount of them. There's a fixed price for that, which includes wages, overhead, G&A, and profit. It's easy to negotiate such a number, and it's much easier to track. You just see how many hours are spent. Materials, if there are any, are at cost plus perhaps a material handling fee if you have one. You do establish a ceiling price or a ceiling number of hours that the contractor exceeds or the subcontractor exceeds its own risk. And a statement of work can be more general. It's additional management to do it than a fixed price one, but you don't have to get too much detail because all they do is do the hours. Next, please. There's limits on fee on cost reimbursable contracts. For developments, 15%. These are statutory limits. For architectural and engineering services, public utilities, but 6%. Other fixed price contract, CPFF, cost plus fixed fee contracts, gets 10%. Realistically, and of course, these limitations don't apply to fixed price contracts, or for that matter, T&M, although T&M never gets much more than the 10% fee because there's no risk there. NIH and NSF set limit SBIR, STTR efforts to 7% fee. Most other agencies are in this range, maybe 8% or around there. Next, please. I'm going to go over some important terms that you want to have in your contract. These came from a Greg Garrett. It's still fairly common, a book he put out. And we'll cover some of the major ones here. There's one or two that he forgot or didn't include in here, which I'll add at the end. Next, please. Just a quick look at them. I'll go back to that one quick. Normal things like acceptance, change management, dispute resolution, force majeure, indemnification. Some of these are rather obvious. IP rights, quality, pricing, performance, termination, warranty. Okay. Acceptance criteria. This is the most important one for you. Who does it, when, and how, and where? Usually it's a report or data. The final acceptance criteria usually can define when you're done with the job. That's always an issue with the sub when they're done and when they expect to be done. You have to have time for review, and if not, complete it. It's deemed acceptable. So in other words, an important thing you want to have and your subs will want from you or sub-grantees is when you give them a document, you have a certain fixed time to review it. If not, it's considered acceptable, deemed acceptable. Also, if it's not acceptable, rejection, what happens? Usually there's a time for resubmittal and correction. Okay, next, please. Delivery performance schedule, you should normally contain standalone milestones. That is, if you have a $100,000 contract, something to be done about 20,000 or 30,000, whatnot. So if you have to terminate the contract, you try to do it by these milestones, and your liability would be limited to those milestones. You have to have an end date, which is usually the final delivery date in a performance schedule. And this is really important. At the end of that date, you cannot charge costs on a cost plus contract without a contract modification approved by the contracting officer. Next, please. Dispute resolution. You always want this because you don't want to be stuck in some strange court, particularly if you're dealing internationally. So it usually requires a time for resolution by the parties' executives before arbitration. Dealing with small businesses, that's pretty easy. You know what the executives are. Arbitration forum, there's a forum, usually ABA. You specify the location, the selection of arbitrators. One should be sufficient. Sometimes they have terms where you have three and one picks another, and you're not involved with that much money that you want to spend that much in this. If there are no arbitration terms, you are subject to suit, usually in the other party's state. In a lot of contracts, they have a dispute clause, and they talk about the different state laws. Most of the state laws in this country are virtually the same in terms of business. There's nothing to really worry about, to fight too much about. The thing you want to worry about here is choice of jurisdiction. Terms might have you litigating in a, like New York or California or things like that. So you might want to save your arguments for things that are really important to you. Next, please. Well, I call this responsibility. This is the indemnification, where each party indemnifies the other for damages they may cause. This should be mutual if you're dealing with private companies and places like that. For states, universities, and governments or labs, they cannot agree to indemnify you, although they're going to want indemnification from you. They all should exclude special and punitive damages and only allow for direct damages. That's damages you can prove that come from the contract or from the effort. Often, they're limited to the value of the contract or a set value. So you're not out on the hook for everything in the world. One thing to note, you cannot limit third-party damages. So the two of you agree to indemnify each other. You cannot limit any third party suing either of you. So they're not a party to that. Even though sometimes they try to do it, it's void by itself. Next, please. Force majeure. This is a common term that prevents termination and relief and provides relief for unanticipated events out of the control of the parties. A flood, strikes, things like that, acts of war. It only provides scheduled relief. Now, today you want to be more careful. Pandemics were a term, but want to look at it more carefully. Be sure to include pandemics as one of the covered events. You may even want to include some idea of who decides whether it's still a pandemic or not. The other clause which is on that thing is like this, is a stop work clause. It's like that. You only get scheduled relief, or actually you can claim under a stop work, but you get to invoke it at for your own reasons. You can stop the subcontractor that think they're in the wrong direction if you think you have to change something. You may pay for a little bit for the impact of the stop, but you have the right to do that for a certain period of time. And you don't need, any pandemic or anything to do that. Next, please. Invoice payment. You always have to have invoicing terms. You should always specify what is required in invoice, the detailed facts you want, hours worked, whatever the prime may want, you want to specify. Determine who approves it. Of course, it'll be you, but when and why and how. Specifically how they can submit them electronically, by copies, by whatnot. And also in the payment terms, you always want to retain a significant amount of money for the final payment. Because once you pay the sub, it'll really be hard to get any help from them. So like 10% or 15% or something that you can use to assure they close out and give you whatever you're supposed to be doing at the end. Next, please. On intellectual property, you got to make sure you retain your SBIR rights. These are a mandatory flow down to subs when you have the SBIR rights. And you want to protect the prior IP rights, the things you developed before the contract, in a data assertion table. And if a subcontract or subawardee gives you some prior IP rights, you have to put those in your table too and protect those. You want to negotiate for sure an allocation of rights agreement, even they're mandatory in STTRs. If not required, you can prepare your own simple agreement if you need one for follow-up options. When I was at Raytheon, we had a lot of tech people running things, and they'd get an agreement with somebody, and we'd give them some money to do something. And they never thought about the follow-up rights. And lo and behold, once we're through with that, they can go to our competitor and do the next phase or the following for them. So you want to make sure you at least have some rights to right of first refusal, some rights to license what they do for a certain percentage or things like that. And of course, you have to have a non-disclosure agreement, and you have to abide by it and make sure it's current and you actually do what it says. Send it to the right people, things like that, or you can lose what you have. Next, please. Subcontract consultant agreement checklist. You have to have a determined statement of work. You want to make sure that's covered and it'll do what you're talking about. You determine if the sub is going to develop or discover IP. If they're going to discover IP, you have different terms you want to put in there, like IP reports and things like that. Typically, you want these to be fixed price agreements. There could be special terms from the prime that you have to flow down. And of course, you'll have your own price and payment terms and general government flow down terms. Is there another, Stanley, let's see the next slide.
Yep, then it's back to me.
Okay, go back that one.
Okay.
Okay.
You wanted me to go back? You said?
Yeah.
Okay.
Also, we didn't include this because it wasn't in Garrett's terms, but these agreements typically have an agreement about contacting with the customer or the prime. You usually want this to go through you, so you don't have a sub-awardee or whatnot making commitments or make discussions or otherwise just talking to the prime without you at least knowing about it and maybe being joining in the meeting. So you want to include such a term of that agreement. Okay.
Okay.
All right. Your turn.
Okay, so as Jim was talking about, now you've written that agreement. A lot of this will also apply to consulting agreements, because often when you're parsing out a significant piece of your technical scope to a consultant, you're going to want to make sure that they're going to abide by the same rules that you would place upon a subcontractor. So anyway, you're moving right along with them. Normally the phase one, although more and more, I have here that it's 6 to 9 months, but we are seeing a lot of phase one projects that are 12 months. And I think over the years, what's happened is so many of the contractors are asking for no cost extensions that I know specifically NSF recommended just starting with a 12-month phase one. But anyway, so depending on, as Jim talked about, when you set up your payment schedule with the subcontractor or consultant, you do want to figure out milestones, specifically, especially if you're going to do a fixed price type arrangement. But I find it very helpful even with the cost reimbursable, because you want to make sure you have a way of checking in on your third parties and making sure that they're really doing what you've asked them to do. So here we just talk about the deliverable being a final technical report, but usually there's a whole lot more that you'd want to ask for, maybe in month one, during the kickoff meeting, and set up how you would do this with deliverables is set up a way of cash flow for that third party as well. But also what we're seeing is if you're diligent about mutually agreeing on these milestones, you're going to run into less problems with that third party. You'll be able to have insight very early on if they're not performing and be able to pivot and actually maybe terminate them if they're not doing what you need, and before they've used up all that money, and then going out to those backups, that stack. However, do keep in mind, if you do end up with the third party being a non-performer and you do want to terminate them, a lot of times the agencies are requiring that you let them know if you're swapping out another subcontractor. Sometimes they even require written approval. So you have to be very careful to understand what each agency is requiring. But anyway, that'll usually be how performance will go. And in phase 2, we're often seeing that, maybe there'll be a prototype and more data or, other deliverables. So that being said, hopefully you've worked on a successful project with that third party, and now you're at the end and it's time to close out. As Jim said, you're going to want to hold back at least a small amount of money to make sure that your third party is going to finish everything you want them to do. It's just kind of common sense, I guess, that, don't pay them everything until you know that they're actually going to finish. Because a lot of times they're going to be integral to preparing the phase 2 proposal. You're going to need their input. And so, even you may want to write in your deliverables in the scope of work that they will provide feedback into the phase 2 proposal. There definitely will be requirements about final patent reporting pretty much from all of the agencies, and the government expects you as the prime to gather that information from your subs and consultants if they were doing a technical scope that could come up with subject inventions. You're going to want to make sure at time of final invoice, it's not that common in SBIR, especially in phase 1, but if there was any government furnished property, you'll want to make sure that's returned and accounted for. And then what we always like to add to the subcontract agreements and consultants is a release of claims. So, and that'll usually state on it the exact amount that you as the prime contractor were on the hook for. And it's basically a signing off that, hey, we're done. We've paid you everything. And they can't come back at you later and say, well, I incurred this cost and you need to pay me. So, there is a lot of housekeeping or administrative work involved even during the end of those projects. So in summary, never ever use a verbal agreement or a verbal order for anything. If you're using federal money, it always has to have a written purchase order, or at least if you're purchasing something, let's say on Amazon, you're going to want to have at least credit card receipts, because all of the money, every penny of it that you get from these grants or contracts needs to be accountable, and you're on the hook. So you have to make sure that you flow that requirement down to your subcontractors and consultants. So, and we can't stress enough, I've seen this many times over, where the small business didn't give themselves enough time to really vet out, who they want to partner with, and they don't choose wisely, and it ends up where these clauses that Jim is talking about, you end up unfortunately in arbitration or in some kind of legal entanglement. So the best way to avoid that is to allow yourself enough time. And I always say, you can see signs back in this cycle during the proposing stage. If they're reluctant to give you what you need to prepare a solid proposal, then you may want to think twice about entering into a relationship where they actually have to perform work for you. So, and be very clear about defining the roles all the way back at the proposal stage, and then carrying that out through your subcontract. So really that sums it up for now with partnering. It can be a lot of fun, and it can be a make or break decision as far as you getting an award. So this is really important. We're really glad that Jill and Kyle wanted to present on this topic, and Jim and I are here if you have any questions. And I guess we do have enough time. We're open for questions if there are any.
Thanks, Sandy. Thanks, Jim. And I'll just say, if you have a specific sort of question, you can also feel free to raise your hand or just message me. I can give you the ability to speak. So if your question feels kind of wordy, I can let you kind of give it yourself as well, and then kind of go from there as well. So I can also let you guys speak up if you would like that as well.
And while we're waiting for questions, I just want to maybe stress some more, and I apologize, I don't know who's on. I'm not going to try and bash universities or national labs, but I do want you to recognize that they're different than you are as a prime contractor receiving money in a commercialization program. So you need to really think about that in terms of making sure your intellectual property, what's the background property? We meet a lot of faculty-owned companies in our practice, and there's a lot of companies where the owner or an employee is going to come out of the university and work 51% on the SBIR, which by the way is a requirement that the PI be 51% in the company. So you have to be very careful that these university people and national lab people understand the requirements, because not all of them understand about the SBIR program. And you as a company at different checkpoints during the life cycle of your project, you're going to have to certify that, yes, my PI did spend 51% in my company working. So if that PI works at a university, they have to arrange it there because often they're going to be giving up some of their benefits. You have to work that out. Sometimes the company will pick that up. So it's all things that you want to get settled up front. I don't see this happening now as frequently, but years ago, I was working up in Denver, and my client had partnered with a university out east who apparently didn't understand SBIR data rights. And, the fact that the government, gets their royalty-free license. And for whatever reasons, they got cold feet about the whole idea of that. And my client, he was working on an Air Force contract on an SBIR. He was left in quite a precarious position because he really needed that kind of expertise. And so luckily the Air Force was patient while he tried to work that out. But in the end, the university backed out. So like I said, I think over the years, universities are much more educated on the SBIR and STTR programs. But just as recent as this past year, I found a scientist at the U of A who was going to be the partner for one of my clients, did not understand the intellectual property requirements. And again, everything just started falling apart. So all of this needs to be clear. Meet with the parties up front, make sure they're clear, even before they give you their input into your proposal. It can really save the project, since you as the prime, and you have everything at stake. You're trying to go on to phase 2, and you need to do it with partners who are reliable.
We had a couple of questions, Sandy.
Okay.
Joe share some experience on intellectual property with universities and whatnot. And I think we can't stress enough how important it is to you decide what you're going to do with your intellectual property, what you want to have before you start. We had one little company who had some university professors involved, and they ended up giving up 5% of their equity to the university and signing up to a fairly large royalty plus the cost of keeping all the patents. When they're planning on moving and dumping this whole thing and moving to different technology, they'll be stuck with that, still stuck with that ownership, and still stuck with those costs, those patents when they go forward. So ideally, you'd kind of figure out where you want to go before you get too far into this, and try to make some arrangements or plans how to get around these things so you still own what you have.
Yeah, often we'll meet companies and they'll say, I wish we had known you were here. And for that, I apologize. My strength is not marketing, but we're here, and do reach out. And there's many other resources that are here as well, to really, and again, I apologize if there's universities on the line, but before you even decide to license technology from the university, really go in with your eyes open. Jim is an attorney. He's worked with many clients, and he can help you, but not after you've signed that license agreement. So, once you've done that, it's pretty hard to reverse. So, and the same thing, the nice thing though, going through the proposal stages and working with these third parties, if prior to award, that it's not going to work out, you can always change, and you can always change even when you're working with these parties, as long as you use the clauses that we're recommending, changes clauses, termination for convenience clauses, stop work. You want to have all those things in place, because you just never know where, what you had in mind, those other parties maybe had something else in mind. And, unfortunately, things can fall apart. But, being proactive and writing good agreements with those third parties up front, it just goes a long ways.
We got another question. Are ACC grants applicable to firms like Summit for preparation of SBIR, STTR proposals?
And I'll ask Kyle to talk about that. I believe they are. Right?
Yeah, if you're referring to the ACA FAST grant, yes, that is applicable to use that for the Summit contract management, the grant writing, consulting, that is covered under the grant. So yes, those funds, if you're referring to the ACA FAST grant, yes.
Yeah, and I should add, our company goes back a long ways. Even before it was Arizona Commerce Authority, we had partnered with the Arizona Department of Commerce as a provider, with SBIR assistance, and that's what we exist to do. So we are here to help you. And you can use us a la carte. You know, maybe you only need us for one small piece. We're fine with that. We just want to see you succeed. So.
And I'll also just say, as a reminder, we'll be sending these slides out after this presentation. You'll be able to, if you have a question after the fact, feel free to email us. Sandy, is your contact information in your slides?
Yeah, it's on this last slide.
Okay.
I noticed, so either the info or the Sandy, SANDY at Summit. And I should add that Jim and I offer a 1-hour free consultation. Just if you want to call and ask us some questions and just get familiar with the services we provide. So we encourage you to take advantage of that too.
I will also say next week we'll have an individual from the NAVSEA, which is the Navy's SBIR program. They're offering also 15-minute one-on-one consultations on the 11th, I believe, and from 2 to 4. So if you want to sign up for a 15-minute time slot, I'm going to pop my email in the chat, and you feel free to reach out, and we can get you booked if you're interested in the Navy's SBIR program and have questions about applying through the DoD Navy. Jill, do you have anything more to add on that one?
No, other than it's a great opportunity. I hope you take advantage, and even if you're interested in learning more about the topics, which cover more than submarines, I think it's a really good opportunity to learn more. And it's via in-person or Zoom.
Good. Like I said, 15-minute time slots, the 11th from 2 to 4. Just reach out. We'll be happy to get you booked, and we would love for you to learn more about the SBIR program from a Navy expert.
Yeah, I'll just chime in. That is pure gold. So definitely take advantage. Because as Jill said, you'd be surprised the breadth of what they are interested in technology. It's quite expansive.
Any other last minute questions before we wrap up for today? If not, like I said, we'll get these slides out to you guys. We appreciate you for joining us today on this workshop on university partnership and contracting with the SBIR program. And we hope you learned everything. You're welcome, Randy. Glad you could make it. Everyone else, I hope you have an excellent day. Thank you again for joining us today.
Thank you, everyone.
Thank you.
Thank you. Bye, everyone.